Hello, I'm Lisa Webster, Senior Technical Consultant here at AJ Bell. Welcome to this webinar on pensions and divorce. So in today's session, I've split it up into three sections. It's the 3 Ps. So I'm going to start by looking at the process of how we deal with pensions on divorce. I'm going to look at some of the practicalities. And then the last section, I'm going to look at the implications for clients who hold protection and if they get divorced and have pension sharing orders on their pension. So starting off with the process then. The first thing to do really is, obviously when you have got couples that are divorcing and you're looking at the assets that they hold, you'll be looking at all their assets, obviously the property usually being the biggest one, other investments that they have elsewhere, and then in turn you look at the pensions. And a valuing pension assets isn't necessarily as straightforward as you might think. I mean, if you have got a SIP, it's quite easy, it can be quite straightforward to get a fund value for that. On most DC schemes, it's going to be fairly straightforward, but there can be more complications and more things to think about. One of the things that's often overlooked is around state pensions. Now, state pensions can't be shared, but that doesn't mean they should be completely be ignored when you're looking at sort of valuing the assets that are held with the couple hold, because if one partner has got a full state pension entitlement and the other one hasn't, that can have an impact on what they need to live on, and in terms of you're aiming for equality, the fact is one decided to work and one hasn't. In that relationship, is it fair that one gets all the benefit and the other one just doesn't, and you may want to equalize that out in other ways. You look at death benefits, the death benefits associated with different types of pensions can be very different, and they can be quite valuable, along with guarantees as well, can be very valuable. And if those are given up on certain kinds of pensions, means that £100,000 in one kind of pension isn't really worth the same as £100,000 in a different kind of pension. So thinking about DB schemes and cash equivalent transfer values, we can obviously, as part of the process of valuing assets, if you have got DB schemes, yes, it is appropriate to get the cash equivalent value, but it's not necessarily that the transfer value that can be achieved. Is that what just can you actually buy the same benefits in a DC environment as you can get under the DB scheme with that value? Now, values have fluctuated a lot over the years, so these things that need to be considered. They're not necessarily a straightforward monetary value to be able to have a comparison. It's also taxation issues too can be considered, because in the hands of different people, pensions are worth different amounts. So if you've got somebody who's a high rate taxpayer, who even in retirement is going to be, if they take income, but they've got other sources of income, when at the time they access their pension, and they're a high rate taxpayer, or potentially even additional rate taxpayer, and then you've got somebody else who's a basic rate taxpayer, and this is their only source of income, it can be more valuable to them because they're paying less tax on it. So all of these things means it's not really straightforward when it comes to valuing pension assets. There's a lot of different points to consider, really. If you're trying to achieve an equitable split, it's not always just a straightforward, let's add up all the different kinds of pensions, the value of this much, let's cut it in half. It's not always that simple, especially say when you've got DB schemes involved as well. If you have got clients that are divorcing and you're looking at how you value pension benefits and sort of how they should be treated, if you're not familiar with this guide already, hopefully if you're dealing with divorce, you may well have seen this before, but if you haven't, it's new to you. If you haven't seen it, I would recommend looking at this report from the Pension Advisory Group. So the Pension Advisory Group are an interdisciplinary group. They set up this discussion. It involves lawyers, actuaries and financial advisors, pension on divorce experts. So they came together to sort of look at the issues with pension sharing, and basically to try and achieve better understanding and consistency of how pensions are treated on divorce, to improve improve practice and improve outcomes, obviously, for divorcing couples. It is a very in-depth report. It's 176 pages long, so it's not like bedtime reading, but it's a great reference document, and you can get that free of charge. It's available on the Newfield Foundation website. So yeah, if you have, if you are dealing especially with DB schemes, you're not quite sure how to value the assets or how to treat them, the things that you need to consider with them, then I would recommend having a look at that. Okay, so once you've got the valuation of all the assets in the marriage, and then you're looking at the pensions, what are your options in terms of what you can do with the pension? Well, there's three basic options. The first one is offsetting, which before 1996 was the only option. So that's literally, well, I'll have the pension, you have the house, or whatever it is. Obviously, in a lot of ways that is the simplest thing to do, but in practice it doesn't always work. The two biggest assets quite often are the house and the pension. But if you get divorced at 30, having a pension you can't access for another 25-30 years, it doesn't help put a roof over your head or feed you today. It's not always practical to do offsetting. But it can still be appropriate to do that in some circumstances, and it can be appropriate to maybe do a bit of offsetting and then maybe do a bit of pension sharing order as well, something like that. So it is one to be considered. Other option, second option I've got on here is an earmarking or attachment order. That's the same thing, just different words to describe it. These came along in 1996 as part of Pensions Act 95, came to force in 1996. And they kind of worked when we lived in a pre-pension freedom world, and kind of with DB schemes, they can work to a certain extent. So with an earmarking or attachment order, basically what it means is that when the pension member starts taking their pension, some of it is earmarked for their ex-spouse. So it's normally expressed as a percentage. So let's say there was a 40% attachment order on the DB scheme. When they first take their scheme pension, 40% of every payment would go to the ex-spouse. That's how that works. And it can be the lump sums as well, and and the income, it goes to them. Lots of issues with that in a pension freedom world, of course, because if couple, particularly if it's been acrimonious divorce, if they've got a pension scheme that's got an attachment order, well, the pension scheme holder isn't going to carry on paying into that. They're just going to pay into another pension scheme after the divorce and build that one up. And then when they come to take retirement benefits, well, they'll just access this one over here. So their spouse doesn't actually ever get anything. Their ex-spouse, I should say, doesn't actually get anything. So there is absolutely no control for the person who's benefiting from the attachment order. It is all in the hands of the original member in terms of how they access benefits, the form of benefits they take, when they access benefits. Obviously, pension freedoms, they can turn it off and on. It is taxed on the original member. So if the pension scheme member is a high rate taxpayer and their income payments are coming out, they're paying 40% tax, and even though some of that is being paid directly to their ex-spouse under the attachment order, and they're a basic rate taxpayer, they still pay the high rate tax on it. It is paid, and there's no way that they can reclaim that. If under pension freedoms the individual was taking a one-off lump sum payment, we have this overtaxation issue of one-off payments under pension schemes, under pension flexibility. They overpay the tax on it, they can reclaim it from HMRC. The ex-spouse who's getting the attachment order doesn't have the ability to do that reclaim. Attachment orders as well, they end if the ex-spouse who's receiving the attachment order, if they get remarried, then that ends it as well. So there's no clean break, there's no control for the person who's receiving the attachment, and there's just lots of issues with them. We do still see them occasionally, ones that have been put in place historically. Depending, if you have got a client that's got an attachment order on their pension, depending on the relationship they have with their ex, if it's all amicable and they work together, it can be fine, it can be worked out. But in a lot of circumstances, depending on the value, whether it's worthwhile as well, but in some circumstances it can be worth going back to the courts and actually replacing it with a pension sharing order instead, in order to give the clean break, which is it's just a better solution, especially in the current world of pension rules that we have now. So it could be worth considering. And so the last option I've alluded to really is the pension sharing order, the PSOs. which is what I'm going to spend the rest of the session talking about, because that's what we use today, really. Is the way we deal with pensions on divorce, where they are going to be split. So pension sharing orders came in under the Welfare Reform Pensions Act 99, came in December 2000. So it is for married couples and civil partners. Obviously not when it first came in, but now we have civil partnerships. It can be applied for people in civil partnerships as well. It does allow a clean break, because the pension member, the person whose pension scheme it is, they have a pension debit applied to their scheme, and there is a corresponding pension credit for the ex-spouse who's receiving the pension, and they can transfer it to a pension. Usually they can transfer it to a pension, but it gets put in a pension in their own name, usually to a pension of their choosing. So it does allow, say, a clean break, which means that the person receiving the pension credit has it completely, it's under their own control, their own pension to access, as per the scheme rules, whenever they like. It is always expressed as a percentage of rights that are transferred rather than a monetary amount, with the exception being in Scotland, when it can be either. So you can have a monetary amount if it's gone through the Scottish courts rather than England and Wales. Most pension rights are shareable, so you can't share state pension. But you can apply a pension sharing order to, occupational schemes, personal pensions, to retirement annuity contracts, Section 32s, active members, deferred members, pensioner members. So not to state pension. It can't be applied to beneficiaries' pension. That's the exception on there for SIP or DC. Pensions, if it's a beneficiary's pension, it can't be applied to that. It has to be to a member's pension rather than a beneficiary's pension on that. So most of the time, I say, the person receiving the pension credit will have the choice as to where they can transfer it to a pension scheme of their choosing. Any slight exception on that is going to be on, I suppose, schemes that aren't exceptionally it's going to be for DB schemes. So it depends on the type of scheme. So, most private DB schemes, the ones that are left, probably will want them to leave, and so they will want them to transfer out. They don't always offer an internal transfer for somebody to join, who's not an employee. But for public sector schemes, like the NHS scheme, for example, then they won't offer a transfer out. The ex-spouse who's receiving the pension credit would become a pension credit member of that pension scheme. So it's still in their own right, and they'll still be, they can access it based on their age, not on their ex's age, so it's not connected in that sense. But because if they don't offer a transfer out, then they'll have it as an internal. So they become a pension credit member of certain of those schemes if it's applicable. In terms of the sort of process itself, the legal process then, so the last part of getting divorced used to be the decree absolute, it's now the final order. It's called on that, so it's the final legal bit that ends the marriage or civil partnership granted by the court. You then have a court order that divides the financial assets, which is usually before the decree absolute or the final order. This is a consent order where if the parties agree basically how they're going to split their assets, and then it's just down to the court to rubber stamp that, then it's a consent order where it's been contested between the parties and they're not reaching agreement, and then the court has to basically say how the assets are going to be split and make that decision. Then that'll be a financial order. In Scotland, you can have a qualifying agreement agreed between the parties, which has to be registered for that to be enforceable, but yeah, it is slightly different in Scotland. If you have overseas court orders, if somebody gets divorced overseas, that cannot be applied to a UK pension scheme. It would have to go through the UK courts in order to be applied to a UK pension on that. An important date in the process is the transfer or effective date. So this is the date that your court order comes into effect. So it's written in the legislation as the transfer date, but I do find this slightly confusing because nothing is actually transferred assets aren't transferred on the transfer day, what they call the transfer day in legislation, but it means, I suppose, it's the rights that are transferred, because that is the date that, you know, the legal right to those benefit transfers from the original member to their ex. So that's the transfer day, but I say assets aren't actually transferred on that day. So what it means is it puts a firm date on that pension, and any contributions or transfers that come in after this date aren't shareable. So, you know, if this has been agreed to the members, and you know, if you've got a member who wants to carry on with their pension and carry on contributing, they can contribute after the date, and you know, be confident, you know, be happy that their ex isn't going to get a share of it. You know, they don't have to start another pension in order to be able to do that, because anything that goes in after that date isn't shareable anyway. And any income taken after that date doesn't reduce the shareable value. So you do have to be careful, really, depending on the values involved, you know, how big a percentage is, because obviously if the member is taking income from their pension after the transfer date or the effective date, obviously you have to make sure they don't deplete their funds and start using the bit that doesn't actually belong to them anymore. So there can be some restrictions on income that can be taken after that date, you know, up until the pension sharing order has actually physically been transferred out. So just want to be aware of on that. And this date will be, it's the later of, say, with the divorces these days, it's final order, it used to be the decree absolute, or 28 days after the pension sharing order is granted, whichever is the later of those, that is legally when it is the transfer date. It's important as well, you know, if the member dies after the transfer date, then effectively what would happen is the pension sharing order would still happen, and the rights would still be transferred to the ex in their own name, and then the bit that's left of the members' fund would then be distributed, you know, as per the normal death benefit process in that scheme. But the fact is, it's not all of it. It's, you know, even if it hasn't physically transferred out, if it's after the effective date, then those rights do legally belong to the ex. It's just waiting for the transfer in practice to actually happen. A few practicalities to consider then. So once we've got, got the decision, we've got a pension sharing order, in terms of how we actually implement it, what you need to do is to send to the pension scheme the pension sharing order, obviously, and the annex, or it can be a minute agreement in Scotland, and that will have in the annex, they'll have the information on what the actual split of the assets is. That's where it will be contained. So obviously the pension scheme administrator needs to see that. It also has information about how fees are going to be split between the two parties, whether it's, you know, either one of them paying it entirely, or whether it's been split 50-50 or split in line with whatever the pension sharing order is. That will be detailed on that. The pension scheme will also need to see, you know, the final order to know that the divorce has been finalised. And then the last piece on this, really important, but quite often doesn't happen at the same time in practice, is the completed pension sharing discharge form. So this is the form completed by the person receiving the pension credit, telling them what they want the pension scheme to do with it. You know, where do you want this sending? Where are you going to transfer this pension to? Your pension credit, where is it going to? Because, you know, obviously the pension scheme administrator can't do anything, you know, with this pension sharing order until they have that information, you know, yes, to see that it's legally possible that they can make the transfer, but, you know, where are they transferring it to? You know, it's really important to try and get that as soon as possible. You know, if you are advising, you know, a client that's going to receive a pension credit, you know, that when this is all going through, that you know what you're going to do with it at the end of it, because otherwise, you know, you can end up in a bit of limbo, really, waiting for this. When you know there's a pension sharing order there, you know, you might have had your, you know, effective date, but you haven't actually made the transfer yet, and it's not really great for either party involved, because the person with the pension credit, they don't get control, you know, they don't make a choice about the investments and what's going on in there until they've actually transferred it into a pension in their own name. But for the person, you know, for the original member, you know, if they wanted to take income, for example, they might be restricted in doing so until the pension credit, has been paid out. So it's not really great for either party. So, we really like to sort of, where possible, have this happen as quickly as possible, have this information so we can start the process, to achieve the clean break between the parties. In law, there is an implementation period. So from the point where the pension scheme administrator has all the information that they need to transfer out the pension credit, so they've got, the PSO and the annex, they've got the final order, they've got the all the documentation they need, so they know where they are going to send the pension credit to. From that date, from when the scheme has all that information, they have 4 months, a 4-month implementation period. So that is in regulations. In practice, we'd always try and do it quicker than that. If there aren't any sort of practical sort of problems with it, but technically speaking, it's a 4-month window. And the pension scheme administrator is allowed to determine the valuation date at any point in that 4-month window. So that's what the regulations say. At AJ Bell, our view is that we do on the first day. So the date we receive all the documentation, once we've got everything that we need, that is what we'll take as the valuation date. We will value the scheme on that date. Once you have the valuation date, this is the first time you actually know how much is going to be transferred. It's not the same as the effective date. So the effective date, I've looked at already, and it could take months sometimes. Hopefully not, but there are cases where it could take months and months before we get all the paperwork in order to be able to actually do the transfer and to implement the pension sharing order. So, and obviously things can happen, markets can move a lot. So, somebody might think, we've got a pension sharing order on £1 million pension fund, 50% order, they think they're getting £500,000, but then, Donald Trump announces some tariffs and the markets crash or whatever it is, and then when they get the effective date through, they've got a very different valuation. Obviously the markets move, there's not a lot we can do with that, but people, the point is, until you've sent all of that paperwork in, until we've got everything there that the pension scheme administrator needs and they do the valuation, you do not know exactly how much that the pension credit is going to be worth until you have that date and you have that valuation. And that's just the way the rules work. There's not an awful lot we can do about that. So it's just one to be aware of. I say we will do the valuation down the first day, when we have all the necessary paperwork. A few practical issues to consider when we're looking at pension sharing orders. The most obvious one is illiquid assets. So it's going to sound really obvious, I'm sure, but if you have a pension, if you've got a SIP which is 90% made of a property and you have a 50% pension sharing order come in, that's a problem. It sounds really obvious. We do see it happen. We do see pension sharing orders come in with a split, and there's just no liquidity in there to pay it out. And it's like, well, if you owned a commercial property, not in a pension, you'd be looking at offsetting, you'd be looking at other ways around it. How do you do it? Do you sell it? Do you split it? How do you split it? On divorce, you'd consider all this. So it's really the same, if you have it in a pension, you need to consider it in the same way. That, how is it magically going to be split? Even if you suggested like an in-specie transfer of part of the property, it's like, well, you've not achieved a clean break then, have you? Even if we could do that, there's no clean break there. So obviously you need to think about practical issues like that. That is an obvious one. Fees, I've touched on in the fact that fees, who's paying those fees has to be in the annex on the pension sharing order. If it's not agreed and put in the annex on the order, then that can cause issues further down the line as to when the pension scheme administrators can charge them, and if it's not on there. So it really should be, it needs to be included in the annex, the who's paying the fees. Cap is on there to represent cap drawdown. If you have a client who is in cap drawdown and they have a pension debit applied to their scheme, then obviously the cap drawdown maximum will have to be reviewed. So it will be reviewed when the pension sharing order is implemented. The review, obviously be a reduced cap, you would expect. that doesn't come into force till the anniversary of the start of the next pension year. So if they've taken maximum allowed under cap drawdown as an upfront payment at the start of the year, and then the pension sharing order goes through, they don't have to pay anything back. It's not an authorised payment. There's no worries like that. It does have to be reviewed, but it takes effect from the start of the next pension year on that. And then the last one here is sort of about information. I suppose it's just a reminder, really, that it is the members' pension scheme. We do have data protection law. The ex, or soon to be ex, isn't entitled to information about the pension scheme. Quite often we will have a divorcing couple where the person who's likely to receive the pension credit wants to know what's in there, usually their husband. It's not always that way around, but in their pension fund, what assets are in it, what's it valued, any information like that. We can't give them that. There's still data protection laws apply. We can only give the information to the member themselves, to the financial advisor if they've got a letter of authority, obviously we can give that information, or we can provide it to the courts. So the court can ask for that information. Obviously, if it's been contested, then the court would apply for that information about the pension scheme, which we would provide to the court under that. But we can't provide it to the person who's not the member. Obviously, if it's all amicable, the member can give it to them. That's fine. That's up to them. Once we've provided it to them. But yeah, just a reminder on that one, because that is another one that does come up and get asked quite a lot. Qualifying or disqualifying credits then. So if the member is already started access their pension before there is a pension sharing order applied, so if they're in drawdown, then the credit is the pension credit for the ex-spouse receiving it is called a disqualifying pension credit. What that means is because the members already had tax-free cash, they can't get tax-free cash as well. So there's not two bites of the cherry kind of thing. So there's no PCLS or UFPLS payments options for them. It'll just effectively go across as drawdown for them. So that should be taken into consideration as well when, back at the start when I talked about valuing assets, because a disqualifying pension credit is worth less than a qualifying pension credit because you don't have a tax-free cash element to it. So that should be taken into account. But so on the plus side of it, if the person receiving the disqualifying pension credit does take income from it, it doesn't trigger the MPAA, so it doesn't restrict what they can pay into DC pensions in the future, in their own right as member benefits on that. But yeah, if it's uncrystallised, then it's a qualifying credit, and then it's just treated like normal benefits uncrystallised. So yes, they can take PCLS, UFPLS under the normal rules on that. Last section then is just to talk a little bit about protection. So in the past, this would have been lifetime allowance protection. We don't have a lifetime allowance anymore, but it can still be important on here. So under the new rules, obviously we don't have lifetime allowance, we have lump sum death benefit allowance and lump sum allowance. And protection, really, the key point is it can give entitlement to higher PCLS, higher tax-free cash, because broadly speaking, the individual's lump sum allowance will be set at whatever their protected PCLS amount was. It does also increase their lump sum and death benefit allowance because the LSDBA is amount of their protected LTA. That one tends to be less important for most people. Most people will live past 75, and so there's no test against the LSDBA anyway when they die. But even if they die under 75, if benefits are paid out as income to the beneficiaries, it's not tested against the LSDBA anyway. Obviously, there may be some clients that only have the option of lump sum death benefits, depending on the type of scheme they're in, where it might be relevant to have it for that purpose. But for the majority of people, keeping protection in the new world is more about giving higher entitlement to PCLS because it gives them a higher lump sum allowance. So in terms of how a divorce having a pension sharing order can impact that, if you have a client with primary protection, rules on that are you can't give up primary protection, but it can be reduced or lost by a pension debit. If you do have a pension debit, then the member has to inform HMRC they need to do that without undue delay, it says in the rules. Obviously, if it's lost completely, they have to give up their certificate. If it's reduced, then HMRC will issue them with a new certificate for the lower amount, which applies from the effective date of the pension sharing order. So an example here, let's say somebody had protected pension rights of 3 million back at A-Day in 2006, and they had a pension debit. This example is just a small pension debit, 300,000 in 2025. All that you do is deduct the amount of the pension debit from the pension rights at A-Day, and then you work out what the protection would have been. So if you would deduct the 300,000 from the 3 million, it's as if they had a fund of 2.7 million at A-Day. So rather than having an enhancement factor of 1, based on them having 3 million, they now have an enhancement factor of 0.8 based on them having 2.7 million at A-Day rather than the 3 million on that. So that enhancement factor is applied to 1.8 million. That's just the way the rules work. It's at the highest level that the LTA used to be. You apply your enhancement factor to 1.8 million, so they now have an LSDBA of 3.24 million. I say in most cases they're never going to use it, but it's there. But importantly, their lump sum allowance is based on them having primary protection still. So their lump sum allowance, i.e. maximum tax-free cash, is going to be 375,000 rather than the standard 268,275. So that's, why it's worth keeping your primary protection. Second example, if you had somebody who had 3 million, again, same value at A-Day, but now they had a pension debit of 1.6 million. Pension rights are now based on 1.4 million at A-Day, which means they wouldn't have qualified for the primary protection because you had to have at least 1.5 million in your pension fund at A-Day. So before your debit, you had your protection of 3.6 million. After, you just have the standard LSDBA of just over $1 million, and you have the standard lump sum allowance of £268,275. So you've lost your 375,000 PCLS on this one, gone down to 268,275. So when you're looking at these, if you have got somebody with primary protection, if you're doing a bit of pension sharing and you're doing a little bit of offsetting as well, it might be worth, if it works out, it won't always, if you can though, considering, can you keep the pension rights, even if it's just over 1.5 million at A-Day, 1.55, 1.51, just a little bit over, just so you keep the protected lump sum allowance as it will be now on that. So it's just worth considering on that. Clients with enhanced or fixed protection, as long as they held them on the 15th of March 2023, which was when it was announced that the LTA was being removed. As long as they held it, they can now make contributions without losing their enhanced or fixed protection. So this is good news, because it means, if they have a high level of protection, which isn't impacted by the pension sharing order, but in the past, they wouldn't have been able to rebuild their pensions without losing that protection, whereas now they can. So it means they can make contributions now and rebuild the pensions that they've lost and still keep their enhanced or their fixed protection. So fixed protection will be depending on which type of fixed protection you have, or you took it out, just the standard levels of protection there. Your enhanced protection, your max PCLS, will be based on whatever you held in the fund on 5th of April 2023, the maximum PCLS you could have taken on that date. So it doesn't matter if a pension debit is applied under a pension sharing order after 5th of April 2023, you still have a maximum PCLS subject to the usual rules of having enough funds to put into income, effectively 25% of your fund, maximum still for your PCLS, but the upper limit will be based on that 5th of April 2023 value. Even if you've had a pension debit since, and similarly your protected LSDBA is based on the 5th of April 2024 value on that. Individual protection then, again, it can be reduced or lost, similar to primary protection. Again, you have to inform HMRC. You've got to do that within 60 days for individual protection. You must inform HMRC, and then again, if you lose it, they'll just get rid of it. If it's reduced, then you get a new certificate, or for the new reversions, it's just a reference number. They'll just give you a new reference number for that. The reduction applies from the effective date of the pension sharing order, but it is slightly different to primary protection, because there is a reduction for each year after the date you took out the protection to when the pension debit was applied. So if you had IP 2014, and then you got divorced 3 years after that, 3 full years after that, then you would have 3 lots of 5% reduction for each full tax year. And you work from 6th of April 2016 if it's individual protection 2016 that's held. So as an example, somebody had 1.6 million 5th of April 2014. They held IP 14, which is the maximum you could have for that was 1.5 million at the time. If you had a pension debit of 400,000 5th of June 2015, just over a year later, that would be reduced by 5% that amount. So instead of taking 400,000 off your value of 5th of April 2014, you take off 380,000 for this example. So that reduces the value below the 1.25 million, which was the minimum you needed for individual protection. So in that example, it would be lost. Now, obviously, we're quite a long way from when these protections came in now, the most recent one being IP 16. So, if you had somebody who got divorced now, you had IP 16, the amount of the reduction, there's more years that have passed, so it's going to be a smaller amount that's going to be reduced for them. Turning to the person receiving the pension credit, it used to be a problem potentially somebody receiving a pension credit if they had enhanced or fixed protection, because you couldn't open a new pension to receive it, and if they only had DB pension, for example, which wasn't receiving any transfers in, and they'd have to open a new scheme in order to receive a pension credit, then that could have caused problems in the past. But with the new rules now, that's all disappeared. So it's not a problem, basically, for the clients who've got enhanced or fixed protection to receive a pension credit, which can happen if you've got very wealthy couples that both got big pension pots, one bigger than the other, you can still share it. You can no longer apply for enhancement factor. It used to be possible if somebody had a disqualifying pension credit, to apply for an enhancement factor, which would enhance the lifetime allowance to reflect the fact those benefits had already been tested against the lifetime allowance in the hands of the original member. That, because we don't have the lifetime allowance anymore, that doesn't exist anymore, so you can't apply for enhancement factors if somebody receives a pension credit. They've gone now. But you may have clients that have got a enhancement factor to the lifetime allowance because they received a pension credit whilst the lifetime allowance still existed. That lifetime allowance, that enhancement factor, will increase their LSDBA if that's relevant, but it doesn't make any difference to the amount of tax-free cash they can take in, because it doesn't increase their lump sum allowance. So in that sense, that they are less valuable, if you like, than previously. But yeah, that's where we are under the new rules on that one. So that's pretty much it for today. So my sort of final summary then is, looking at valuation of pension assets, it's not as straightforward as it could be. It's not really a case of just looking purely at the monetary value. Different assets are worth different amounts in different people's hands. Depends on the type of pension scheme. I mentioned about, CETVs from DB schemes, guarantees, death benefits, taxed differently, whether they've got PCLS attached or not. So you need to look at those in a bit more detail, I'm afraid. Attachment orders can be problematic. I certainly wouldn't recommend doing attachment orders. Technically you can, I really wouldn't recommend it anymore. If you have got clients with attachment orders, it may be appropriate to change them to a pension sharing order to get a clean break, depending on the circumstances. Pension sharing orders, yes, they give a clear break. Think about the practical issues, I say, especially if there's a liquid investments in there. And if you have got clients with protection who are getting divorced, there's just a few points to consider depending on the type of protection. it's not as bad as it used to be. You know, if it had some fixed protections, you're fine with. But yeah, if they've got individual primary protection, yeah, there's just a few points just to consider, take into account before you make the decision on how the assets should best be split on those. Okay, so that is all from me for today. I do hope that has been useful, and thank you for watching.